If a man utters talaq 3 times, he can get divorce. And also, under Quran, it is mentioned that the pronouncement of each talaq should accompany a waiting period of 3 months iddat for reconciliation. And during the reconciliation period, if they are not reconciling, the husband, by pronouncing talaq the 3rd time, can get a divorce, which is effective and unalterable. Also made an argument by saying that most of the Muslim communities which are prevailing are Sunni, 90%, and they don't make triple talaq a valid one, so it must be declared void. Arguments supporting respondents by Mr. Kapil Sibal, supporting IAMPLB. He made an advent by saying that since Muslim marriage is a private contract, the concept of judicial review is not acceptable, and also mentioned that Article 13 is something that does not include personal laws. The court can access validity only after Parliament made any changes to secular activities, freedom of religious practice under Art 25(2), and also, triple talaq is not discriminating against Muslim women, and for bad marriages also she can claim remedies under Special Marriage Act 1954, Union of India. He made an advent into the argument by declaring the constitutional validity of 3 grounds called triple talaq, polygamy, and nikah halala. The AG argued on the basis of the Narasu Apamali case, stating that immunity to uncodified personal law from fundamental rights challenges is at the point of a revisit. Arguments by Manoj Goel in favor of Shayara's husband. He made a major argument in the point that divorce is actually between 2 individuals and no state action is involved for that. J. Nariman made a counter-argument like Sharia Act 1937 includes the state, therefore the state's involvement is mandatory. Findings. The court, by analyzing the following points, came to the final judgment. Amit Chanda, a petitioner's side advocate, made a very important point like triple talaq is not recognized by Muslim personal, Umesh Lalit, and also concurring judge called J. Joseph. The findings from which the dissenting judges, J. Kehar and Jabdul Nazir, gave their judgment are: Kapil Sibal, a respondent side's lawyer, gave a statement stating that Muslim marriage, being a private contract, is not subjected to judicial review. Mukul Rohatgi, another respondent's lawyer, stated that it is an intrinsic part of personal law and not subjected to declare its constitutionality. Manoj Goel, also a respondent's lawyer, stated that divorce is between 2 individuals. Therefore, the involvement of the state in it is not necessary. Reasoning. The solutions which are provided for the questions which are raised in the issues. Whether the practice of talaq-e-bid'at specifically mentioned in instantaneous triple talaq an essential practice of Islam. Essential practice is something that relies basically